So enjoy watching Parliament TV and indeed listening into that submission from Ministry of Justice.
Introduce themselves.
Thank you so much, Chair. Minister of Justice, good morning. Honorable members, I'm Lamek Hamwata, Member of Parliament for Pemba Conference and a member of this committee. We sincerely welcome you for this morning's interactions. Thank you.
Thank you so much, Chair. Minister of Justice, good morning. My name is Sande Chanda, Member of Parliament for Kanchibia constituency and the Vice Chairperson of the committee. Thank you.
Thank you, Chair. Good morning. My name is Priska Enchimanongwe, and I'm from the office of the clerk. Thank you.
So, Justice, you can proceed with the introductions.
Good morning, Honorable Chairperson, Honorable Members. My name is Masiliso Chivambo. I am the Deputy Chief Parliamentary Counsel. I want my colleagues to introduce themselves.
Good morning, Honorable Chair. My name is Agnes Msiska. I'm Principal Parliamentary Counsel from the Ministry of Justice. Good morning, Honorable Chair, Honorable Members. I'm Kanemba Sinyanga Banda, Principal Parliamentary Counsel, Ministry of Justice.
Good morning, Honorable Chair and Honorable Members. My name is Agnita Petulo, Senior Parliamentary Counsel, Ministry of Justice.
Good morning, Honorable Chair. Good morning, Honorable Members. My name is Chawezi Chirwa, Parliamentary Counsel, Ministry of Justice.
Good morning once again. My name is Chinga Mioto, representing Karab Central, and by courtesy of the committee members, I chair this committee. Justice, as you interact with the committee, the Portfolio Committee of the National Assembly of Zambia, under the current laws, there's Cap 12, Powers and Privileges of the National Assembly. It gives the honorable members the immunity against any prosecution in relation to matters that they handle on the floor of the House. And so today, as we are together in this room, that Cap 12 with its immunity is extended to you. So as we are interacting, you are wearing a full jacket of immunity arising from Cap 12. So you will not be prosecuted, just like the honorable members are not prosecuted as they handle matters. Also, the immunity is extended to the submission that you are about to present to this committee, that it cannot be used in any court of law in Zambia as part of evidence or otherwise. However, the same Cap 12, if it is proven that you deliberately misled, that you had the intent to mislead this committee in its deliberation, then the Cap 12 will be applied against you. The whole idea behind the Cap 12 is to enable the stakeholder to express themselves freely and fairly, just like the honorable members do, so that the report which is being constituted through such deliberation becomes a resolute document to serve the people of Zambia. And as we are handling the two bills, so that these laws, they help in the governance of this country, and they also help in the implementation of the laws. So that the and enable the Zambians enjoy their lives. So maybe I'm seeing members who are online. Honorable members, if you are ready with introductions, you can proceed.
Thank you very much, Chair. This is the Honorable Dr. Clement Andereki, a member of Parliament for Katombola constituency and member of this committee.
Thank you, Honorable. Okay, others will join. So, okay, you can proceed. You can proceed. Thank you, Honorable Member. So, at this point, let me allow you, the one who is mandated to present the submission, to read the presentation.
Honorable Chair, I seek your guidance. Since we are looking at two bills, should we make both presentations at a go?
You make one. I don't know, Honorable members, what do you suggest? Yes, Honorable.
Thank you, Chair. I think we'll go submission by submission,
Okay.
bill by bill. After
Yes.
the bill, if there are concerns, we look at them then before we move to another bill.
Okay. So we shall handle a bill after the other. Yes, you can proceed.
Thank you, Honorable Chairperson. We will then begin with the explanatory memo on the Penal Code Amendment Bill number 74 of 2026. Honorable members, it is worth noting that the existing penalty relating to the offense of stock theft in the Penal Code Act, Cap 87 of the laws of Zambia, as amended, has failed to serve as a strong deterrent to potential offenders and thereby failing to protect the economic asset of individuals and provide sufficient redress for victims of the offense. Therefore, the bill before you seeks to amend the Penal Code so as to strengthen the penalties relating to the theft of stock and as a result address the increasing prevalence of stock theft, particularly in rural and farming areas where livestock is an important source of livelihood. The bill, once enacted, will strengthen the penalties relating to the offense and act as a strong deterrent to potential offenders, thereby enhancing the criminal justice system and contributing to the development of the legal framework. Honorable members, the specific clauses of the bill are that Clause 1 simply provides the citation of the Act once it is enacted, and Clause 2 seeks to amend Section 282B of the Principal Act by strengthening the penalty to be imposed on potential offenders who are convicted of the offense of stock theft. The penalty has been revised in the case of a first offense to imprisonment for a term of not less than 7 years, and in the case of a second or subsequent offense to imprisonment for a term of not less than 10 years. Additionally, the clause is empowering the court, in addition to the penalties that are imposed under the section, to make an order for the restitution of any stock or produce that is stolen to the owner in accordance with sections 179 and 180 of the Criminal Procedure Code Act, Chapter 88 of the laws of Zambia. I submit, honorable members. Thank you.
Thank you for that presentation. Honorable members, there we are. Any observations and questions? Yes, Honorable.
Chair, I was trying to look at what could be the legal changes, but it's good that we have the Minister of Justice. Probably you can give more details on the last, which is the court may, in addition to the penalties imposed under this section, order the restitution of the stock. Could you give more details? What does it mean here? Because, Chair, if you recall, I think we have looked at this penal code to do with the stock theft. I think this could be the third time. And the duration of 7 years and 10 years, it may not be that new to this committee. Of course, the other time we also looked at making it non-bailable. Initially, it was the second offender. Then we had looked at the first offender also to make it non-bailable. So kindly let us know what is new critically for now, and of course giving details on the last this restitution of the stock. Thank you.
Yeah, Justice, you can respond to that observation.
Chair, so it is worth noting that currently the orders for restitution are actually already sitting in the Criminal Procedure Code, and that's why the bill is referencing sections 179 and 180. So these are powers that the court already has. We are just making the cross-reference and making it clear that even in the event that there is any stock or produce that is stolen, the court can order restitution. If I may, I can read the actual provisions. Sections 179 currently of the Criminal Procedure Code provides, where upon the apprehension of a person charged with an offense, any property is taken from him, the court before which he is charged may order A, that the property or a part thereof be restored to the person who appears to the court to be entitled thereto, and if he be the person charged, that it be restored either to him or to such other person as he may direct, or B, that the property or a part thereof be applied to the payment of any fine or any costs of compensation directed to be paid by the person charged. Section 180 also provides similar provisions, Chair, and so all that we're doing is making a cross-reference and showing that restitution can also be ordered in addition to whatever penalty that the court would have imposed in the section. So say, for example, for the offense under B, which is being upped, in addition to any fine or prison sentence that is given, the court would then also order restitution. That's all that is being included, Chair.
Yes.
Are you trying to imply that if, for example, this suspect stole 10 cows from my crow and apprehended on sentence, this suspect can still be ordered to give me the 10 cows? Is that the meaning?
The court can order the restoration of those 10 cows to yourself, yes.
Yes, Honorable Ndeleki, proceed with your question.
Thank you, Chair, for the opportunity, and good morning to the Minister of Justice. Chair, my issue has to be almost on opposite to what the previous member, the Member of Parliament for Pemba, was saying. This bill has been before our committee, but it appears each time it comes with some changes. We feel that the issue of stock theft, we had agreed previously that first offender is non-bearable, second offender non-bearable, first offender can get bail. But we feel that a 7-year sentence is very, very lenient. You see, this is like an armed robber. Someone goes in your bank and withdraws. People get pension. Their whole pension money, they invest in livestock. Some of us who are farmers, you can't come and say 7 years, what and what. That offense must remain non-bearable. Anybody who steals stock, to discourage stock theft, it must be non-bearable. Whether first offender or second, in order to stop or deter people from stealing livestock. We would like to see a situation where theft of stock is non-bearable by Minister of Justice. We want people to respect private property so that they do not steal. So I don't know what has gone wrong with the issue of making that offense non-bearable completely. I thank you, sir.
Yes, Honorable Justice.
Before the answer, Chair, the other part was not responded to. Remember, my observation is that unless I've forgotten, the 7 years and the 10 years, it is not new to this committee. This is the issue that we looked at, unless maybe I've mixed up the issues. The non-bailable, we looked at it. The second, when we had the bill the last time. So I was trying to seek to know what is the difference that I'm not seeing, because she has referred to restitution, which is already sitting in the constitution. So I'm failing to understand why we're having this bill. Is there anything new that probably we need to understand, Chair?
Yes, Honorable.
Thank you, Chair. Maybe just the Minister of Justice could just run us through what the penalty is right now. You know, I think that will answer the question being raised by the honourable members. Thank you.
Thank you, Honorable Chair. When we look at the Penal Code Act, which was amended in 2023, the penalty for stock theft is as follows. A person, that's section 282B, a person who steals any of the following commits an offense. 3, the provision which is subject to the amendment. A person who is convicted of an offense under subsection 1B is liable, A, in the case of a first offense, to imprisonment for a term of not less than 5 years and not exceeding 15 years. And B, in the case of a second or subsequent offense, to imprisonment for a term of not less than 7 years and not exceeding 15 years. That's the current provision. And then the proposed amendment in the proposed bill, section 282B, the proposed amendment reads as follows. A person who is convicted of an offense under subsection 1B is liable, A, in the case of a first offense, to imprisonment for a term of not less than 7 years, and B, in the case of a second or subsequent offense, to imprisonment for a term of not less than 10 years. So those are the proposed changes, Honorable Chair. So currently, the law is first offense not less than 5 years, not exceeding 15 years, but the proposal now is not less than 7 years. And then currently second or subsequent is not less than 7 years and not exceeding 15 years. But the proposal now in the bill is for a term of not less than 7 and not exceeding 15 years.
And the position of the bill?
Just to add, Chair, that the offense of stock theft still remains non-bailable, as a result of Act Number 4 of 2026, the amendment to the Criminal Procedure Code. So the penalties that are being provided for are in relation to a conviction. So the offense is still non-bailable, Honorable Chair.
Yes, Honorable.
Thank you, Chair. So, Chair, if I'm getting the witness, Minister of Justice, this amendment is basically dealing with a minimum sentence, and it's a minimum sentence that is being adjusted upwards. So the maximum still remains at 15. Okay, so I just want to get that clear, because so as it sits now, the minimum for the first offender is 5 years, and the maximum is 15. And then for the second offender, the minimum is 7, maximum is 15. With amendments coming in, first offender, the minimum goes up to 7, and the second offender, the minimum goes up to 10. So I was just looking at the memorandum, because clause 2 is only referencing to the minimum. Is are we doing away with the maximum? What is happening to the maximum? Thank you, Chair.
Justice.
Thank you, Honorable Member. Yes, indeed, we have done away with the maximum. So meaning that the court now has a discretion to determine what the maximum would be. But the law is saying
as a minimum, it can't be less than 7 years for a first offense, and it can't be less than 10 years for a subsequent offense. But the maximum threshold, that is now for the court to determine. The law is not prescribing the maximum threshold.
Yes, Honorable.
Thank you, Chair. I think that was very important to just highlight so that we know that there's also discretion now being left to the for the courts to deal with a maximum. So what we're doing now is to look at the minimum. For the first offender, it can be less than 7 years. For the second offender, it can be less than 10 years. And depending on the gravity, probably the scale of the theft and any other circumstances, the courts now would probably say 20, 30, 40. Okay, shall I submit?
Okay. Justice, there was an observation by Honorable Andereki of Katombora showing that the current, the bill which is showing 7 and 10, according to him, is saying due to the economic value of the object we are talking about, the subject, the animal, the stock we are talking about, his suggestion and view is that the penalty to him, it is still low. The issue of 7 years below. There are issues like where I come from. We have some individuals who entirely depend on cattle. They don't have any other source of livelihood other than cattle. So it is a very important aspect and item in our communities. So the issue of 7, what is it that brought up the issue of raising from 5 to 7? And what if, as we are giving the discretion to court, and then the sentence seems not to rise so much? What will be the benefit of the victim by the adjustment in this manner?
Chair, it is worth noting that when sentencing is being considered, the courts look at various issues when a person is brought before them and is being charged with a particular offense. So the circumstances obtaining in relation to that offense will usually determine how the courts will then sentence an individual if they are found guilty of the offense that they have committed. The law is simply providing what the minimum penalty would be, so that is 7 years. We take note of your concerns as honorable members to say that still is not sufficient. So we have taken note that you are proposing that it should even be higher, but all that this law is prescribing is that it can't be less than 7 years. So at the end of the day, if a person comes for the first time having stolen, let's even suppose one cow, they will be given, and if they're found guilty, then they will be given a sentence of not less than 7. So the minimum that they'll be given is 7 years. But in terms of the principles of sentencing, there's a lot that the court looks at. They look at the circumstances of the particular case, and they would also look at whether there are any mitigating factors to not grant a particular sentence. So there are various principles that the courts would look at. But in terms of the minimum, it is 7 years and nothing less than that.
Yes, Honorable Fonyimba, you can proceed with your question.
Thank you, Chair. Chair, I just want to understand what you are saying with the minimum.
of 7 years and 10 years. Then we give all the powers to the judge. The sentence allowed to any amount of years that judge is prescribed, he or she will fix to person in agreement. Now, Chair, for me, I think that I am making the court a noise in this case. Yes, stop theft to Chair. It's something we cannot just stand because it brings over the people that are funding the court funding. Now, my question is, why is it so difficult that the Minister of Justice having to propose the maximum sentence? Because even in murder cases, whichever case, there are maximum sentences. Why is it that we are looking this open-ended? Because I see a situation where somebody has stolen the cows because the minimum is 7 months. The judge will just say 6 weeks. If the sentence is passed, and let's not see the justice or the court to be sent. They could also err at the certain point. I propose here that the ministry should propose the maximum, not just leaving it open, because it's going to be 7 years, 1 month, 7 years, 3 months. So we need to have a maximum, not exceeding 20 years, okay, or maximum of more than 20 years, not just leaving it open-ended. They are all, the courts are managed by humans, they are not supernatural. I thank you, Chair.
Maybe to just want to add a word or two. I once had an interaction with the Law Development Commission. There was a workshop in Kafue, and I put it to them that it's important that we have good leaders. And I've kept this comment from the Law Development Commission. Their response was that, yes, there's need to have good leaders, but there's more need to have good laws. Why? Because if you have a good leader and you have good laws, two things, it will serve the community. So the Honorable Member for Nyimba is expressing a point where the limit has not been set. So, like he's saying, for sure, those presiding officers are human beings. There can be whatever like you have put, but let us not forget that we are human beings. So what if it will work like the Honorable Member has put it? Meanwhile, the value could be more, but because he's a human, he has been given that mandate. According to him or her, he will just give that sentence in that manner. What will be the benefit? Why can't for sure, why can't a limit be a maximum the way it was in the current, that there is a limit of not more than 15? Why can't it be in the same way, either 20 years or 30, since the minimum has been raised? Yes, Honorable Chanda.
Chair, thank you so much. I'm trying to, so that probably we look at the issues around court discretion, and maybe something that the witness could address themselves to, where sentences remain proportionate, where circumstances of theft vary significantly. So again, we can have subsistence theft, but we can also have organized criminal theft, and whether or not, we should impose a maximum. So the maximum sentence should be the same for subsistence theft. Here is a person who has just stolen one animal, and here is a cartel that is stealing hundreds and whatever of animals. Should the sentence be the same? And I think this is where, in addressing yourselves to the question of the court discretion, where we find the person who has stolen one animal and someone who has stolen 200 animals are given the same sentence in terms of the maximum, because this is what the law says. So in terms of court discretion, are you trying to look at a situation where theft varies significantly, so that we still don't say, oh, listen, you stole one goat, you stole one cow, you're going in for a maximum of 15, you stole 500, you're going in for and so that is again the thing. I'm trying to buy into what could also be the thinking around allowing the court discretion to look at the mitigation and some of the where sentencing is proportionate to where circumstances vary significantly. Chair, that's my question.
Yes, Justice.
Honorable members, thank you. It is worth noting, honorable members, that setting a limit is actually not going to deal with the issues that you are raising. The converse is also true. If you set a limit, indeed, as the Honorable Sunday has said, you end up charging someone who has very aggravating circumstances in relation to the offense in the same manner as someone who would have less aggravating factors. So when the courts are sentencing, honorable members, they would consider aggravating factors such as, was there use of a weapon? Was this done as a cartel, as per the example that was given? Was it premeditated? How did they, what was the manner in which they conducted themselves in actually stealing the particular stock? So if you set a limit, you would then not allow the courts to be able to even sentence someone to more years than 15 years. So would it be possible for us to determine that, okay, in this particular case, if there are aggravating circumstances such as use of a weapon, they left a particular household beaten almost to death, and then the law is saying only 15 years. Would that be fair? But at the same time, you would then look at the fact that if a person steals only one cow, is the minimum sentence of 7 years then fair? So obviously, the law is looking at what is the economic value of the asset that is being stolen. And you'd have to consider it from just one cow, for example. So that's why the law is saying the minimum is 7 years, because the law has determined that that is what the minimal economic value would be. But it is not setting a limit, because the courts are being allowed to determine it on a case-by-case basis and to be able to sentence even greater than 15 years, than 20 years, depending on what this particular offender did while they were stealing the stock.
Okay. Honorable members, any more observations, questions on this presentation? Okay, then we can proceed to the next submission.
Thank you, Honorable Chair. I will present the Public Gathering Bill number 71 of 2026. The background: the bill seeks to repeal and replace the Public Order Act, Chapter 113 of the Laws of Zambia, in order to provide for the protection of the freedom of assembly and association at a public gathering and regulate the conduct of a public gathering for the preservation of public order and public safety. The specific clauses of the bill Part 1 of the bill provides for preliminary provision. Clause 1 sets out the title of the bill and the commencement date of the bill. Clause 2 provides for the interpretation of words and phrases used in the bill. Clause 3 provides for the application. The clause extends the application of the Act to all public gatherings held in the Republic. The clause further sets out which public gatherings are exempt from the application of the Act, such as public gathering held by the President or for the purpose of a wedding ceremony. However, the clause provides that the exemptions applicable to the Speaker, First Deputy Speaker, or Second Deputy Speaker, and a Minister, Provincial Minister, Member of Parliament, Mayor, Council Chairperson, or Councillor shall not apply during an election campaign, during an election, or where Parliament is dissolved in accordance with the Constitution. When you move to Part 2, which provides for regulation of public gatherings, Clause 4 provides for duties and obligations of authorized officer. The clause obligates an authorized officer in the performance of that authorized officer's functions to protect and promote the freedom of peaceful assembly and association, freedom of expression and freedom of movement, to act impartially in the administration of the law, and to ensure that the right to freedom of assembly is exercised with due regard to the interests of public order and public safety, among others. Further, the clause empowers an authorized officer to order participants at a public gathering to dispense from a particular area within a reasonably specified time, where the authorized officer has reasonable grounds to believe that the public gathering poses a direct and imminent threat to public order and public safety, and the threats cannot be adequately contained under the powers granted to an authorized officer, or to the public gathering, or the public gathering is likely to result in the loss of life of a participant or a member of the public. Clause 5 provides for duties of organizer. The clause mandates an organizer to cooperate with an authorized officer in the planning and adoption of measures for the maintenance of public order and public safety at a public gathering, and to ensure that participants at a public gathering comply with any written law and any condition attached to the holding of a public gathering. Clause 6 mandates a person who intends to hold a public gathering to notify an authorized officer at least 5 days before the proposed dates of the public gathering. The clause further sets out what should be contained in the notice and requires that the notice is delivered to a police station in the area where the public gathering is proposed to be held. Clause 7 mandates an authorized officer to acknowledge receipt of the notice within 24 hours of the receipt of the notice. Further, the clause provides that a notice that is not acknowledged within 24 hours of its receipt by an authorized officer shall be deemed to have been received by that authorized officer. Clause 8 mandates an authorized officer to approve the holding of a public gathering within 3 days of the receipt of a notice, and empowers an authorized officer to attach conditions to the approval of the holding of a public gathering in order to ensure public order and public safety. The clause further permits an organizer to proceed with the holding of a public gathering where a notice is deemed to have been received by an authorized officer and the public gathering is not approved by an authorized officer. Clause 9 sets out the circumstances upon which an authorized officer may restrict the holding of a public gathering, which include where the venue for the public gathering is unsuitable for the purposes of the crowd and traffic control, or it interferes with the other lawful business. The clause further requires an authorized officer to notify an organizer in writing of any restrictions imposed on a public gathering, and permits the authorized officer to lift such restrictions where the organizer takes remedial measures. Clause 10 mandates an authorized officer, organizer, participant, or any other person to respect and uphold the rights of the media to monitor a public gathering. Clause 11 prohibits a person, except an officer of the Defense Force or National Security Services, from wearing an attire at a public gathering that signifies an association or connection with the Defense Force or National Security Services of the Republic or of a foreign state. Further, the clause permits a person to wear an attire connected with the Defense Force or National Security Service of the Republic in the course of a lawful stage play, circus performance, or any other theoretical performance. Clause 12 prohibits a person, other than in the course of a public duty, from possessing a firearm or weapon at a public gathering. Clause 13 prohibits a person from holding a public gathering without giving notice of the public gathering, in contravention of a restriction imposed on the public gathering or contrary to the provisions of the Act. Clause 14 mandates an authorized officer to keep and maintain a register of notices received by that authorized officer. We move to Part 3. Part 3 of the bill, which provides for general provisions. Clause 4, under that part, provides for Clause 15, which permits a person aggrieved with a decision or action of an authorized officer to appeal to the minister within 14 days of the decision or action. Further, the clause permits a person aggrieved with the decision of the minister to appeal to the High Court. Clause 16 grants immunity to an authorized officer for acts done in good faith in the performance of that authorized officer's functions under the Act. Clause 17 empowers the minister to make regulations for the better carrying out of the provisions of the Act. And the last clause, which is Clause 18, repeals the Public Order Act, Chapter 113 of the Laws of Zambia, and also sets out the savings and transitional provisions once the Act is operationalized. Thank you, Honorable Chair. I submit.
Thank you, Justice, for the presentation. Maybe before we proceed, let me allow the member who has not introduced himself to do so.
Thank you, Chair. Good morning, our witness. My name is Monti Chinkuri, MP for Kanyama. Thank you.
Honorable members, there we are. Any observations and concerns and questions in relation to the submission? Yes, Honorable Member for Pemba.
Thank you so much, Chair. My question is on Part 2, regulations of public gathering. Then you flip from that page. That is approval of public gathering, that's 8. Are we there? Yes, and I want to quote, subject to Section 9, an authorized officer shall, within 3 days of receipt of a notice under Section 6, approve the holding of a public gathering in the prescribed manner and form. I'm wondering why the word disapprove is not there. Probably maybe if you can give more details, because when there's an application, there are two things that are likely to happen: to approve or to disapprove. Why the law is just talking of approve without putting the word or disapprove? Chair, I hope my question is clear.
Justice, you can respond to that.
Thank you, Honorable Chair. So if you go to Clause 6, we do not have an application there. What we have is a notification to an authorized officer. That's why when you go to Clause 7, it's not talking about disapproving, because it is not an application but a notice. I submit, Honorable Chair.
Yes, Honorable.
Chair, when there's a notice, I give a notice, there is an approval there or disapproval. Does it work like that? If it is, why don't we have the word disapproval?
Yes, Justice.
Chair, I think in answering that question, what needs to be seen is what the mechanism of this proposed legislation is. The mechanism, as earlier stated, is that a notice is going to be given. This is stemming from a right that is falling under the Constitution. Everyone has the right, has the freedom of assembly and association. So based on that right, you are then going to notify an authorized officer of your public gathering, because obviously there is need to ensure public order and public safety. Remember that one of the objectives of this particular law is to protect the freedom of association and assembly for the purposes of public order and public safety. So yes, you have the freedom, but for the purposes of public order and public safety, you need to notify authorized officers that we intend to have a BCD public gathering that is not exempted in accordance with clause 3. When that is done, the authorized officer is receiving your notice and then approving the notice. However, in order to again ensure public order and public safety, you've got mechanisms in the law such as the referenced section 9 or clause 9, which is allowing public officers to restrict under certain circumstances. So instead of having disapprovals, there's mechanisms such as restricting public gatherings in certain instances, again for the purposes of public order and public safety. Authorized officers are being permitted to attach conditions to the holding of the public gathering, again for the purposes of public order and public safety. So those are the mechanisms of this legislation, as opposed to approving and disapproving the holding of a public gathering based on a constitutional right.
Yes, Honorable Monty.
Thank you, Chair, and our witness, thank you so much for your responses. I think just in line with what my colleague has asked, the spirit of this amendment is to regulate public gatherings, and we know that through that a number of issues that are not allowed in society normally take place. Now, we are saying a notice will be advanced to the controlling officer or supervisor officer or authorized officer, where in event he does not respond, then that will be deemed to have been received. Okay? Going further, you are saying in event he does not respond, the organizers should go ahead and carry out that public gathering. I think I heard you correctly. Now, if that being the case, why the need to notify the police when, whether the police authorized officer responds or not, the gathering will continue, bearing in mind that these should be regulated to avoid unforeseen, omissions by those who were gathered. Chair, I submit.
Yes, Justice.
Thank you, Honorable Member. Clause 4, subclause 3, which is setting out the duties of authorized officers, has an insertion there that is worth noting, Honorable Members. It says nothing in this section shall be construed as depriving an authorized officer of the powers granted to that authorized officer under any other written law. Authorized officers in this particular law are police officers. So police officers at the end of the day still have a mandate to ensure public order and public safety. This law is mandating anyone who wants to hold a public gathering to notify. And even in the event where a response is not given, you can still proceed with your public gathering. But that does not negate the functions of authorized officers to come and ensure that that public gathering, there is public order and public safety. So the not acknowledging your notice is an administrative function. And the law is simply saying where that administrative function is not exercised, you are well within your right to still go ahead with that public gathering. But at the same time, authorized officers are mandated to still ensure public order and public safety. And they will still have those powers because the law is saying it does not deprive them of any other powers that are granted to them under any other written law. And we know that they have powers to ensure public order and public safety.
Yes, Honorable.
I hear you, and that's a very good response. However, there are some reasons that have been advanced in the past that, well, I'll use the term denied. Certain grouping has been denied to, hold these public gatherings. And the reasons that will be advanced is lack of manpower. Those are some of the issues. I mean, I think learning from the past that have been advanced as to why certain gatherings have not been instituted. You realize that somewhere, maybe the officers have been deployed somewhere. Now, maybe that gathering or whatever function that they are conducting there will take some bit of time. Now, here's a situation where officers are deployed somewhere. Then, because of time that has been allocated to this process of holding that public gathering comes or does not allow officers to respond, then the moment that public gathering takes place, then officers realize that, oh, here there's something that is taking place. Meanwhile, they have got something more serious their side. Then they come and disperse people. Don't you think now from such conducts, the public will rise and say, no, we are being victimized, you are not allowed to. So I just want to make sure that we don't leave any room for anyone to start complaining because of the laws that we are, or the wordings that we put in our law. Chair, I submit.
Yes, Justice.
Thank you once again, Honorable Member. Again, Honorable Members, I think we need to read the law within its context. So I will begin with sub-clause 4, again on the duties of the authorized officers. 2, which is giving them powers to disperse, is saying the authorized officer may order participants to disperse where the authorized officer has reasonable grounds to believe that the public gathering A poses a direct and imminent threat to public order and public safety, and the threat can't be adequately contained under the powers that are granted to the authorized officers. Or B is likely to result in a loss of life of one or more of the participants or a member of the public in the surrounding area of the public gathering. So again, those are the parameters that the authorized officers are being given. They are not just dispersing for the sake of dispersing. So obviously, an authorized officer who is exercising their functions would therefore have to show that the dispersing was on the basis of the factors that are given within the legislation. Again, when we go to clause 9, which is providing for restrictions, or before that, in fact, clause 8, which is providing for conditions to the approval of the holding. Again, the law is saying for the purposes of ensuring public order and public safety. Because remember, Honorable Members, that public order and public safety is the overrider for this legislation, and the authorized officers have the mandate to ensure public order and public safety. And the law is giving those parameters. So at every given point, the law is showing you what the parameters are. And the overarching principle is public order and public safety. Again, when we go to clause 9, which is providing for restrictions, again, the parameters of those restrictions are clearly laid out in the proposed legislation, Honorable Members. And again, there you will see that, for example, A, where the authorized officer is in receipt of a prior notice to hold a public gathering on the same date at the same time and same venue as another proposed public gathering. And even then, when restrictions are imposed, subclause 2 is telling you that they will inform the organizer of the reasons for the restriction at least 3 days prior to the proposed date, and they are also being invited to take remedial measures to address the reasons for the restriction. So again, the law is setting parameters. So this power is not just being exercised arbitrarily. The law has set the parameters for the exercise of the powers that are being granted to the authorized officers. I submit. Thank you.
Yes, Honorable Chanta.
Thank you so much, Chair. Chair, with your indulgence, allow me to have a couple of questions for the Minister of Justice. Maybe I'll go the first set, Chair, with your indulgence. I'll be very quick. The first question is how does this bill reconcile the requirement for prior notice and approval with the right to freedom of assembly under the Constitution? And as we know that this right is not contingent on permission. Chair, the second one is why the bill is shifting from a notification regime to a de facto authorization regime, given that Section 8 requires approval before a gathering can proceed. The next question, Chair, would be what safeguards exist to prevent the abuse of reasonable belief under Section 9, subsection 1(1), which allows restriction based on anticipated disorder. So what safeguards are we bringing into the picture? Lastly, under this set would be, can the Minister of Justice justify whether the limitations imposed meet the test of legality, necessity, and proportionality in constitutional jurisprudence? Chair, I submit.
Justice, you can proceed.
Chair, I will respond to some and my colleagues can augment. So, firstly, honorable members, the very first question that is saying reconcile the requirement for prior notice and approval with the right to freedom of assembly, I think it is worth noting Article 21, which actually provides for the freedom of assembly and association. Under Clause 2, the Constitution provides, Article 21, Clause 2, it says, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article to the extent that it is shown that the law in question makes provision A, that is reasonably required in the interests of defense, public safety, public order, public morality, or public health. So therein lies the rider. You do have the freedom of assembly and association, but that freedom of assembly and association is covered by other conditionalities such as public order and public safety. So therefore, the need to give prior notice is for the purposes of ensuring public order and public safety. The need for the authorized officers to be able to approve, again, based on the fact that they are looking at public order and public safety, again, is based on the need to ensure public order and public safety. So yes, you have the freedom of assembly and association, but that does not overpower the need to ensure public order and public safety. And that's why the law comes in to be able to set limits to your exercise of that freedom. But that limit is only on the basis, again, of public order and public safety. With regards to the safeguards for the abuse of authority, the law has provided an appellate mechanism. The appellate mechanism is under clause 15. So anyone who would be aggrieved with a decision or an action of an authorized officer first has an administrative appeal to the minister, and where you are aggrieved by the decision made by the minister, you then have your appeals that lie to the High Court. So at that point, your grievance would then be adequately dealt with. If you feel that there was an abuse of authority on the part of an authorized officer, the law is providing an appellate mechanism for you to be able to seek redress. I'll allow my colleagues to augment, and then I will come back and add on if need be.
Thank you, Honorable Chair. I think just to respond to the question on the shifting from notification to approval to authorization, in addition to our earlier submission, and also in line with what the Constitution provides as a right to freedom of assembly, the bill has provided that once you give the notice and you have not received this approval, then the organizer can proceed. But the approval is only to ensure that the public safety, public order is maintained. So when you look at even the parameters of the approval, they've been clearly provided for, or there are conditions attached to them, which is that there should always be public order and public safety. Therefore, it's not really it's not negating or affecting the right of assembly. So the notification has been tailored to ensure that the law complies with the freedom that has been provided for in the Constitution. I don't know if I've answered the question correctly. Thank you.
Thank you, Honorable Chair. In relation to the question on the justification for meeting the legality, proportionality, and necessity test, Honorable Chanda, if you look at Article 21 in the Constitution in relation to the protection of freedom of assembly and association, the article provides that nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article to the extent that it is shown that the law in question makes provision, A, that is reasonably required in the interests of defense, public safety, public order, public morality, or public health. As earlier stated, Honorable Chair, the rider for this legislation is public order. So when you look at this article, it actually permits this piece of legislation for purposes of meeting the legitimate goal, which is to ensure public safety and public order. So for us, we have actually met this test, Honorable Chanda. I submit, Honorable Chair.
Honorable Zulu. Okay, yes, Honorable Martin.
Chair, thank you so much. Witness, thank you for your responses. Section is 11, prohibition of attire in connection with defense force and the security officers. It clearly states that a person shall not wear an attire at a public gathering. Wondering that public gathering that signifies an association or connection with the defense force or national security services of the Republic or of a foreign state. Despite subsection 1, a person may wear an attire connected with the defense force, national security services or the Republic in the course of a stage performance, circus performance, any other theatrical performance. A person who contravenes commits an offense. Now, I thought the spirit of this was to bar people or citizens from putting on this attire. Now, we are saying public gathering, a theater. So it means it allows someone, or like myself, I just put on this uniform. I'll be moving freely, not at a gathering and not at a. So I just want to hear your comment on whether it generally prohibits any person from putting on this regalia other than those two instances. Thank you, Chair.
Maybe before you respond to that question, I wanted to indicate to all of us that we are supposed to be winding up our discussion, as we still have one more witness awaiting. However, I have that is on the general provisions. It is to do with the Article 15, is it article or section or whatever? It is to do with the appeals. You know, the mode or the type of government that we have in Zambia. The cabinet is drawn from an active parliament, meaning elected members of parliament who face dissolution at some point, as we are waiting the dissolution just in the near future. So what happens now? Because here it says, a person aggrieved with the decision or action of an authorized officer under this act may, within 14 days of the decision or action of an authorized officer, appeal to the minister. There's no limit. There's no limitation as to when these public gatherings should be done or made. Here comes a situation, the parliament has been dissolved, meaning the position of the minister is vacant. Any clarification on such? Justice, you can proceed.
I shall begin with the first question on the attire wearing. So the law is prohibiting anyone from wearing any attire in connection with the Defense Force or any national security service. So that's the starting point. You're not allowed to. The only circumstance under which you can be allowed to is if you have a circus performance or any theatrical performance. Even then, you're not walking around post that theatrical and circus performance with that attire, because the law is saying don't do that. You can only do it when you're actually undertaking a circus performance or theatrical performance. And honorable members should actually note that this is actually a provision that is already sitting in our penal code, even presently. Under section, let me just go to it. Section 182 of the Penal Code on offenses relating to official uniform. Even under that particular section, it says, provided that nothing in this section shall prevent any person from wearing any official uniform or dress in the course of a stage play performed in any place in which stage plays may lawfully and publicly be performed, or in the course of a music hall or circus performance, or in the course of bona fide military representation. So those are the limits that the law is setting. So even ordinarily, presently, no one is allowed to dress as an officer out there, because at the end of the day, you are misleading the public. The public ought to be able to know that there's a police officer. So if I walk out and I'm dressed as a police officer, I am then misleading everyone around me, because if someone comes to me and is saying, please help me, and I'm wearing a police officer's uniform, at that point, I would have misled the public, and it would actually cause more harm. And therefore, this provision is just seeking to buttress what is already sitting under the penal code presently. Honorable Chair, in relation to the appellate question, if you could just repeat it for us again, Chair, we'll be grateful.
Okay, thank you. The question is in relation to section 15, where an aggrieved person is within 14 days can make it known that is aggrieved to the office of the minister. Now, knowing that the portfolio of minister somehow there's connection to the parliament, which gets dissolved as we are just waiting the few days to come. So what happens in such a situation that parliament is dissolved, meaning there's no minister? So how do you handle this appeal?
Thank you very much, Honorable Chair. When you look at the Statutory Functions Act, that is Chapter 4 of the Laws of Zambia, the Act provides that the functions that are vested, for example, in the ministers, they are, let me read 3. 3 is clear that a person, for the time being, vested with a statutory function, such as the minister, in their absence, such functions may be exercised by the president. So where the minister exercises these functions on behalf of the president. So if a time arises where the office of minister is vacant, then such powers revert back to the president, being the owner who has delegated such functions. Thank you.
Okay. So, yes, Honorable Chanda.
Thank you, Chair. Chair, that was a very critical question, and I want to thank Council that she was on point in, I think, in responding to that question. Because, I mean, ministers act on at the thing of the president, so those are delegated responsibilities. Chair, I just want to ask, it's a devil's advocate, if you allow me to, that Chair, the sections 3.2 bring in exceptions that public officials, for example, the president, ministers, MPs, can have these public meetings unregulated. Doesn't this create a two-tier system in constitutional rights? Contrary to the equity and non-discrimination before the law. And I'm asking this for on behalf of the people of Kanyama. Chair, I submit.
Maybe in addition, I have also an observation where those portfolios are excluded or this act does not apply. Is it not putting these these persons at risk of security? When I go into the constituency, I inform the police that I have a meeting at some point for their information. But if I'm totally excluded, the position of the MP is totally excluded, all these portfolios, wouldn't there be the insecurity? How will this person be protected? Because the attendance of the police will now be like it's none available. So how will the security of this portfolio person be protected, be secured? Thank you.
Thank you, honorable members. I will begin with the last one in terms of protection mechanisms. Again, as earlier stated, nothing in this law is preventing authorized officers from exercising the functions that are placed upon them under any other written law. They are required to ensure the protection of the president. They are required to ensure the protection of the vice president. And these officers, when they are holding public gatherings, would still administratively inform authorized officers of these public gatherings, because they are going there in their official capacity and as holders of a particular office. So the protection mechanisms would not be negated by an exception granted under this particular law. With respect to a two-tier system in terms of constitutional rights, it's worth noting that the exemptions are looking at particular offices and the powers vested in those offices, and therefore the exemptions are being granted to those offices by virtue of the fact that they are holding certain offices and would therefore have to conduct public gatherings just by virtue of the fact that they have certain functionalities under various pieces of legislation. But aside from that, what is being provided under subclause 3 is actually also worth noting, because in relation to the exception, it still provides that those exceptions wouldn't apply during an election campaign, they wouldn't apply during an election, or where Parliament is dissolved in accordance with the Constitution. Thank you, Chair. My colleagues can augment if
Thank you, Chair. I think we have nothing to add. I think our colleague has put it correctly.
Yes, Honourable.
Chair, it will just be a comment and not a question. Maybe food for thought for Minister of Justice, where the bill is concentrating concentrating on the excessive discretion in the police officers, but maybe without providing for independent oversight at decision making stage, noting that the affected or aggrieved party will have to appeal, and appeal processes, which is okay. But then can't we have a mechanism that provides for oversight whilst a decision is being made? Maybe that's something that you may not respond to right now, but just food for thought that yes, we've appealed, we've provided for a mechanism where the aggrieved party can appeal a decision, but who's providing oversight whilst a decision is being made? Knowing that the appeal process could take time, like after 14 days from appealing to the minister, then you go to the High Court, that becomes a longer route, and some of it could have been avoided if we had sufficient oversight at the decision-making stage. Chair, submit. Just a comment.
Are you able to comment over a comment? Okay. Honorable Msanje, you have come at a time where we are almost done, but you can make yourself known.
Thank you, Chair. Morning, Minister of Justice. I'm Joseph S. Msanje, Member of Parliament from Babara Constituency in Joma. You're most welcome. Thank you.
Maybe you'll be sitting with us, or?
Yes, Chair. If the committee needs a permanent witness, we will leave a permanent witness.
Okay, thank you. Thank you very much, Justice, for appearing before this committee, and I think you have ably attended to the members' questions and observations. I think that's how it should be. Usually, the statute here shows that the apex in the ministries are supposed to be interacting with the committees. This is because there shouldn't be any pending answers, but I'm sure members are satisfied with your responses. However, we have to remove the immunity so that you are on your own justice. Thank you very much and have a good day.
Thank you, Honorable Chairperson.
Parliament TV, the station that is dedicated to bringing Parliament closer to you. That was a submission from Ministry of Justice, making a submission to the Committee on Legal Affairs, Human Rights and Governance. This committee is sitting in Wesley Nyirenda Committee Room here at Parliament Buildings. And the Bill, National Assembly of Zambia, Bill number 74 of 2026. This bill seeks to promote the protection of freedom of assembly and association at the public gathering, to regulate the conduct of the public gathering for the preservation of public order and public safety, and to repeal and replace the Public Order Act 1955, and to provide for matters connected with or incidental to the foregoing. And the other bill that the committee is considering is the Penal Code Amendment Bill, National Assembly Bill number 74 of 2026. You'll recall that this bill was presented on the floor of the House by the Acting Minister of Justice. That was on Thursday, 30th April 2026. So this bill seeks to revise the penalty relating to the offense of theft of stock and to provide for matters connected with or incidental to the foregoing. This is the Penal Code Amendment Bill, National Assembly Bill number 74 of 2026. So these two bills are being considered by the Committee on Legal Affairs, Human Rights and Governance. So earlier on, we heard a submission from the Ministry of Justice. Later on, we do expect yet another witness to make a submission. This is the Law Association of Zambia. It will be making a submission to the Committee on Legal Affairs, Human Rights and Governance. For now, we take a short break. We'll be back with you when the next witness is ready to make its presentation to the Committee on Legal Affairs, Human Rights and Governance.
Moments in our lives that live forever. Moments like witnessing the thunderous call of a natural wonder, or experiencing the roar of the wilderness as its residents come to life, and the lively slither of a river teeming with untamed wildlife. There are moments in our lives that live forever. Moments like experiencing the adrenaline rush of close encounters with nature's thrills. The exquisite indulgence of luxurious treats, kissed by the radiance of the African sky.